First of all, I want to welcome everybody to the phone call, to the presentation today. We have a good, hopefully some good information to communicate to everybody on the phone. I want to welcome all our clients and our friends of the firm. I hope you're all doing well and are having success working remotely, have good Wi-Fi from your house, and hopefully you're feeling healthy, and if not, hope you're taking your vitamins and pushing through. Before I introduce our presenters, I do want to take a moment to ask all of you to please keep your phones lines muted throughout the call. I'll be doing the Q&A session on behalf of everyone. We have received some questions in advance. We have some previously prepared questions we think would apply. If we have the phones on mute, we'll be able to avoid background noise. Today's discussion topic, first of all, my name is Luis Flores. I'll be your moderator today, so let's get that out of the way. So I'm Luis. You'll be hearing my voice throughout the presentation. And once again, thank you for joining us this Thursday afternoon. Today's discussion topic is navigating the ever-changing real estate landscape and how the CARES Act may impact it. Obviously, now within the title is the words COVID-19, but that's kind of the heart of the matter, the subtitle, right? Again, I'm Luis Flores. For those of you that don't know me, I am a vice chair in Saul Ewing's real estate practice group. In my spare time, I run the Miami office of Saul Ewing. I've been practicing for over 20 years, so this is the third economic crisis I've been a part of as a lawyer, the first being, of course, 9/11, then the financial crisis, housing bubble in 2007, and today's pandemic crisis, which I think is a little bit different than the rest, as we all might say. I regularly represent developers of all types of projects. Of course, since I'm in South Florida, my concentration is high-end apartments, condominiums, and hotels. I was drafted to moderate today's panel because I did a similar panel last week for our Florida clients and friends. As a Florida counsel, I represent institutional lenders out of New York, so I'm familiar with both sides of real estate transactions. During the last recession, I assisted developers and lenders in negotiating loan workouts and closing the sale and purchase of distressed debt assets. So both of those will probably pick up in the next few months as we see how this plays out. So as I said before, since you are all on mute, I will be asking the presenters any questions you might have. If you want to send me any questions during the program, please send them to the following email account, events@saul.com. That's special, sounds like, it's like the word events, special events at saul.com, EVENTS@saul.com. Send your questions by email. We'll try to get to as many questions as we can. When we did the Florida presentation, we found that the Q&A portion was as long, if not longer, than the presentation portion of the discussion. One last piece of housekeeping before we begin. It wouldn't be a law firm presentation if we didn't put a disclaimer out there. Although we are giving some guidance and recommendations on today's call, we shouldn't be considered formal legal advice, and is not intended to create a lawyer-client relationship just based upon the call. And of course, our recommendation is to, seek professional counsel, seek professional legal counsel, and discuss your particular facts and the nature of your situation. Of course, any of us on the call are happy to do that for you, and you probably already are clients of the firm anyways. So without further ado, let me introduce our presenters for today's discussion. They put a lot of time in putting together these materials and are prepared to discuss it. As I mentioned before, I work out of the Miami office, but all of our presenters work out of the Chicago office of Saul Ewing, and they call it their home. Our first presenter is David Wayne. David's a partner in Saul Ewing's litigation department. David is a trial lawyer who handles complex business disputes, particularly those involving real estate, commercial contracts, and employment-related matters. For his clients, which include successful entrepreneurs and business owners, David serves as a trusted advisor and outside general counsel. At the firm, David's one of the few partners that sits on both the litigation and real estate departments. So that's why we asked him to participate in today's program, given his experience as his experience as a litigator regularly requires him to help business owners triage the issues they face, which is clearly going to be necessary during the current times. David, why don't you go ahead and David Wayne, why don't you go ahead and introduce yourself and say hello to our audience so they can get to learn your voice.
Yeah, thank you, Luis. Hello, everyone. Thank you for joining us this afternoon. As Luis said, I kind of have a unique sort of skill set, if you will, in the fact that I both sit on and work with the transactional real estate attorneys quite frequently on issues relating to leasing, property management agreements. I also have a real estate brokerage background. I'm not a practicing broker, but I have that skill set that I utilize in connection with my sort of day-to-day work as well. And then I also, as part of that and the skill set I've developed, spend a lot of my time in court handling these types of disputes when they get to that level. I've been practicing for over 20 years as well, similar to Luis, and I've been at the firm for all but 2 years of my career.
Perfect. Thank you, David. Our second panelist today is Barry Katz. He's a partner in our real estate practice group. Like I, he's a transactional lawyer. Barry represents entrepreneurs, individuals, LLCs, and corporations in the sale, acquisition, leasing, and financing of properties, both in Chicago and across the country. Barry's got nearly 40 years of experience closing complex real estate deals, so he's able to identify issues and help clients across the real estate landscape, commercial, retail, industrial, and multifamily assets. Barry has extensive experience representing landlords and tenants in the leasing of a wide variety of retail, commercial, and industrial properties. And given the scope of Barry's experience, he definitely has the skill set to address the challenges you may be facing during the current environment. Barry, why don't you say hello to everybody and introduce yourself?
Hi, I'm Barry Katz. Thank you for the introduction, Luis. I have been practicing for over 40 years. It's gone pretty quickly. And like you, Luis, I would say I've been involved in not only 3 of these financial crises, but I also was practicing during the Black Monday in 1987. So I also have that range of experience. I also hold a real estate broker's license, though I don't actively practice as a real estate broker. And I think the skill set that I bring is that throughout my career, having my client base is many landlords, many tenants, many owners, many sellers. And because of that, I normally try and I'm able to find common ground. And I understand both sides, let's say, approaches to each transaction.
Excellent. Thank you, Barry. That will be helpful for today's conversation. Our third panelist is David Yance. David is a counsel in the firm's real estate practice group and focuses his practice on commercial real estate law, including acquisitions, dispositions, leasing, and financing. David Yance has significant experience drafting, reviewing, and negotiating leases and related agreements for office, industrial, and retail premises on behalf of both landlords and tenants. In that capacity, David has drafted and negotiated hundreds of retail leases for regional and super regional shopping centers. David also regularly represents owners, developers, and municipalities in connection with the acquisition and disposition of commercial real estate. David's practice also includes a representation of both lenders and borrowers in connection with financing secured by commercial real estate, including acquisition loans, bridge loans, and construction loans. David Yance, why don't you say hello to our audience and introduce yourself?
Hey, thanks, Lou. David Yance, like Lou said, I handle, all facets of commercial real estate, acquisitions, dispositions, a lot of leasing work, a lot of financial work. On the leasing side, I've represented landlords and tenants and probably thousands of leases over the years. On the financing side, I've represented both borrowers and developers, both borrowers and lenders, ranging from financing transactions, from $1 million to $100 million. I've been at Saw Ewing for about 4 years, and before that, I was in-house at a real estate development company in New York.
Perfect. So for those of you that may be joining us a little bit late, we have a couple of Davids presenting today, one in the litigation department / transactional. It sits on both sides of the fence, and David Yance, who's primarily transactional. So I'm going to try to differentiate between the two of them by using their last names, David Wayne and David Yance. So you'll hear me doing that throughout the presentation so you guys can understand who's speaking, who's going to be called upon. As we begin our presentation, I want to remind everyone that you might want to have handy the materials that were distributed earlier today. If you don't have them in front of you, check your emails. They were distributed around 11 a.m. this morning by Christine Laudenbacher from our firm, And again, if you want to send any questions in during the presentation, send them to events@sol.com. That's events@sol.com. So let's get started. David Wayne, with the arrival of April and April rent obligations, we're clearly seeing a second phase of issues related to the pandemic business shutdown. If the initial phase of issues was marked by landlords concerned about correct practices following OSHA cleaning guidelines and notices regarding infected employees and how to comply with the government shutdown orders, the second phase is now about how do these facts impact any obligations that these parties may have as a tenant, as a vendor, as a contractor, as a borrower, to comply with their respective contracts. And I think at the heart of this discussion has been the force majeure provision or any common law defense that may be available to performance. So why don't we start with force majeure provisions and how they are coming into play in the current situation, David Wayne.
Yeah, thank you, Luis. Yeah, this is, I always describe it when clients come to attorneys and say, hey, I need a short one-page agreement or a short contract, and then lawyers come back and they give them a contract that's got all these extra pages and all this boilerplate. And force majeure is one of those clauses that's generally found in the miscellaneous section of buried in the back of a contract. The first thing to understand with force majeure is it is a contract-based principle. It is not a common law concept. And what I mean by that is if it's not in your contract, it's not going to be read into your contract, at least certainly in Illinois, and I think most other states probably follow that similar type of rule. Courts are going to take what's in the contract, they're going to interpret it based on the language of that, and if it's a clear and unambiguous provision, they're going to apply that provision as it's written. We have in the materials, there's a few samples of various force majeure clauses, and you'll see they're not just in leases. There's a sample from, and these are actually real-life samples that we pulled from contracts. They're in loan agreements. It's a pretty typical provision that you'll find in the back and the boilerplate of most contracts. And so with the understanding that it's not a common law principle, that it's contract-based, that's a really good starting point, meaning that you really got to look at the language and what it applies to. And, more often than not, you're not going to find a force majeure clause that has the word pandemic in it. I actually have seen some. We have some in our office that some clients have used that contain that word. But generally speaking, at least now, you're not going to see it. I certainly expect on a going forward basis, it's going to be a standard term that's going to show up in force majeure clauses in the future. You're going to see certain things, however, like government action, government shutdowns, acts of God. Whether or not this pandemic is an act of God, it could be a debatable point. But you're going to certainly see those types of things in the standard force majeure clauses. The next thing to understand with force majeure is more often than not, it's pretty typical, and in fact, in the samples we have here, they all contain these disclaimers that force majeure does not excuse payment obligations, generally speaking. You can certainly have a clause that will, but more often than not, the types of clauses you're going to see is it's not going to excuse rent. So for example, in the first sample we had, it says, each of the obligation of tenant, except the obligation to pay rent, and it goes on. So even if it applies, it's not going to be a clause you can necessarily rely upon to either stop paying rent, or if you're a tenant, or to stop paying your mortgage if you're an owner, a property owner. Another thing to understand is that force majeure itself won't terminate a contract. It will excuse performance for a period of time, but in and of itself, it's not necessarily a get-out-of-jail-free card to cancel or terminate your agreement. So for example, it could come into play if there's an hours of operation clause in a lease where you have to keep your lights on for a certain period of time. Obviously, if government orders out there and it shut down the building, for example, a shopping center where it's deemed to be non-essential business, you're not going to be able to comply with that. So it would excuse that type of performance, but it wouldn't, as I said earlier, necessarily excuse the payment of the rent during that period of time. So that's sort of the general primer on force majeure and what we're seeing. We haven't really seen a lot of litigation on it yet, or actually haven't seen any litigation on this yet, because this pandemic is so new and everything's changing on a daily basis that it's not, and we're not in court yet on these issues, but we certainly expect as the future, we go down the road here, there's going to be a lot of arguments and things, and we're going to start seeing this in frequency in court in terms of interpreting whether or not it applies. So that's a general primer on it. Barry, I'd love to, if you have some thoughts on kind of what you're seeing in your world on the transactional side as it relates to force majeure, it'd be great to hear from that on that aspect.
Most leases have a force majeure clause, but I agree with you. They also have, and it's very common in a lease where there's almost always a provision, or a well-drafted lease from a landlord perspective, that the covenant to pay rent is independent of any other provision set forth in the lease. So on that basis, landlords will, I'm sure, be relying on that provision to, seek to prevent a tenant from not paying, making an argument that they shouldn't pay rent. The one thing about force majeure is that the litigators in our firm are telling us that judges will say that a pandemic is a force majeure event, even if it's not specifically listed in as such in an agreement in the lease. The one key question is if you get in front of a judge, and we don't have the answer to that, is that will payment be excused, or will the solution be extension of the contract, in this event, the lease, in this case, the lease. Another question is, okay, we have an event of force majeure, who bears the risk? The landlord or tenant. So that's not specifically an answer to your question, but it's the type of analysis that's going to be occurring on a case-to-case basis.
Excellent. And this is Luis Flores again. And I want to ask kind of both of you this, because when we talk about, I know we're focusing a lot on landlord-tenant relationships and leases that have force majeure provisions. But my understanding is this, lease is just, I know this is a fact, lease is just a contract, right? There's purchase agreements out there, there's those loan agreements out there, there's construction agreements with GCs, you have service agreements with vendors or purchase agreements with vendors for either operations or businesses. So this same analysis that you're applying to leases applies to any of those types of contracts, right, David Wayne? To the extent you have any obligations between two parties, first you look to see if the contract has a force majeure provision. That's your first point of action. Isn't that right?
Yeah, absolutely. Absolutely. And, to your point, Luis, yeah, it absolutely can apply, and often it is contained in a multitude of types of contracts. It's, as I said, you'll find it buried in the back of a contract next to construction clauses and interpretation of words and the notice provisions, and then all of a sudden you'll have a force majeure clause there describing, saying here's what applies. As I said, if it's not there, it's very unlikely a court would read it in to a contract. There are other issues that could come up that we'll probably talk about later today. But a court, there's all kinds of case law, certainly in Illinois, I suspect, and other jurisdictions that basically say it's not the court's job to read terms or limitations or conditions into contracts that were not placed there by the parties. And so if it's not there, you're not likely going to be able to read it into it. And if it is there, you're going to follow the language. And if it's clear and unambiguous, that language is going to be applied as written.
See, that's the thing that scares my clients the most, David, is that it's almost what we're finding more often than not is that because the force majeure provisions normally are pretty broadly written, right, or other causes of action or other acts of God, they try to have like an umbrella, right, like a catch-all to say if there's something else that happens out there that delays performance or it's unexpected, right, an act of God, that can excuse performance. But more often than not, those force majeure provisions are written in favor of one of the parties as opposed to the other. So more often than not, unless you're that party in whose favor it's written, it may be hurting you as the party that doesn't want to perform. They're trying to look to the pandemic as a look. Let me push pause here. Are you saying then that you expect Illinois courts to always look at the provision, or can they maybe look to an executive order to maybe excuse performance, notwithstanding the force majeure provision, or do you think the force majeure provision trumps all if it's in your contract?
Yeah, I think as a starting point, kind of let me start with in normal times, and this is a little bit of speculation on what the court's going to do, but in normal times, the court's going to look at the provision and say, okay, this is going to control, if it's clear and unambiguous, right? If it's not, you can look at external, sources, parole evidence, things outside the face of the agreement itself. But in normal times, they're going to start with that. I think, obviously, we're dealing with unusual, highly unusual times now. And so what do I suspect is going to happen? I suspect courts are going to look for reasons to not hurt anybody. And so I suspect we're going to see broader readings of force majeure clauses. If acts of God somehow isn't in there, or pandemics specifically isn't in there, I suspect courts are going to try to find ways to say, okay, we're going to excuse performance. There are other common law defenses too that if not contained in the contract, we fully expect people will get into things such as you're going to start hearing about frustration of purpose and impossibility, commercial impracticability. There's things that are going to be, we fully expect those are going to come to the forefront more as well as we go forward. And again, to my speculation somewhat, I certainly think if there's a way the court's going to be able to figure out how to not punish somebody during these crazy times, I think that, these are courts of equity in large part we're talking about, and equity being the operative word. I think we're going to see courts try to bend over backwards to figure out ways not to kind of find the path of least resistance or the path that's going to harm the parties the least.
And so I know that here in Florida, for example, and I assume the same applies in Illinois, to the extent that parties get into a dispute about the performance of a contract, right? And they want to, whether it be a lease agreement or a purchase agreement or construction agreement, all those examples I mentioned before, if they want to defend their performance, a party's going to use whatever they have at their disposal. They can use all the common law defenses you mentioned. They can try to refer the force majeure provision in the contract if it's there to help them, or explain why it doesn't apply to them. I mean, that's permitted under Illinois law and case law, correct? You don't have to pick your defense.
Correct. You can certainly raise whatever defenses or affirmative defenses that you may have in defending your claim. And when I say affirmative defenses, what I mean by that for the non-lawyers is it's really a burden of proof issue. So if it's something affirmatively you're raising, like impossibility or even force majeure, it's your burden to prove that. So as a defendant, so. But yeah, we fully expect there's going to be a laundry list of items and things that people are going to throw out there to say, well, even if force majeure doesn't excuse this, these other defenses that I have should. They're tough defenses.
Understood.
I mean, they're not, but yeah, they're absolutely going to get into it. As we go forward and we see more litigation popping up.
And Illinois.
Go ahead.
Go ahead. I was just going to say, in Illinois, when you try to rely on impossibility of performance, that party has to generally show that they've tried all practical alternatives to permit performance. It's almost like when you're under a lease, if a tenant defaults, the landlord has to show that they've made an attempt to mitigate their damages. So there's going to be that, at play. And I think based on what David said, I think 3 or 4 years from now, when all this finally hits the courts and decisions are being issued, there's probably going to be a whole new line of case law, addressing this, which unfortunately for us sitting here today is not particularly of that much help.
Right. So as we talk about, now let's shift back a little bit more to the landlord-tenant relationships, lease issues. I know obviously a lot of us in the practice are dealing with landlord-tenant issues day by day. We're getting these phone calls left and right. What are you seeing from the tenant perspective or from the landlord perspective, Barry Katz, what lease issues are you presenting themselves?
All right. Well, obviously at this time, the landlord-tenant dynamic is fluid and changing almost, we'll say certainly weekly. As the pandemic is highlighting, there's significant interconnectivity between customers and clients of tenants and the tenants. For example, is the tenant able to conduct business remotely and receive some business income? And if so, what is that percentage of that income to normal operations? Or is the tenant basically not able to bring in any income? To me, I think of a flow chart that runs from the customers and clients to tenants to landlords and then to lenders. And each piece of this connection has its own set of demands and problems. In analyzing and discussing the options available to landlord and tenants surrounding issues of rent abatement, rent deferral, and performance under a specific lease, to me, there's a practical reality versus a legal reality. As discussed by David Wayne, many force majeure provisions do not specifically mention an event such as a pandemic, and it is uncertain if a court will include the pandemic as not foreseeable or as an act of God. And even if that pandemic is included as a force majeure event, many leases provide that the payment of rent is a covenant independent of all other terms and conditions of the lease. However, even where the landlord can legally state that a tenant is not excused from the payment of rent, practically, in the present circumstances with extremely low demand for tenant space, a landlord, I'll say a reasonable landlord, would not want to evict his tenants to create an empty space that needs to be leased when the existing tenant can begin to pay rent within a time frame as uncertain as that time frame might be. Remember that a landlord will incur costs to relet a space such as tenant improvement costs and broker's commissions. On this basis, a landlord has an incentive to attempt to work with the tenant to find a solution. And this same practical versus legal reality will be applied to lenders who do not want to start foreclosure proceedings. And as I said, it's an extremely fluid situation where in our state, Governor Pritzker issued the stay in place order through March 31st. It's been extended through April 30th with the possibility that it will be extended through May, making payment of May rent by tenants challenging and uncertain. Now for some real life examples. Importantly, every lease will have its own specific fact situation that can impact the leverage of either landlord or tenant. This includes whether the lease is guaranteed and the length of the remaining term of the lease. So example number one, a client of mine, is a dental practice in downtown Chicago with 6 employees. Although a health professional, he's not an essential business, as his practice is more focused on cosmetic and reconstructive elective dentistry. The tenant reached out to the landlord and requested rent relief. After closing the multi-tenant building, the landlord responded and asked for a proposal. So in late March, we contacted the landlord and requested a credit of rent between the date of the governor's order, March 21st, and the end of March, and an abatement of rent through 1 month after the governor rescinds his stay-at-home decree. Landlord responded on April 2nd by offering a deferral of rent for April and May with the option to amortize the amount of the deferral over the term of the lease or to extend the lease for 2 months. As an aside, in our practice, we're finding this to be a pretty typical landlord position right now. In addition, importantly, the landlord required financial information beyond that set forth in the lease, including a list of all financial aid applied for and or received by tenant resulting from the CARES Act, and a list of any insurance proceeds related to rent from tenant's insurance claim made as a result of COVID-19. For example, business interruption insurance. The client has decided to request a 6-month abatement of rent. His argument is that in seeking the abatement of rent, is in the past, he had 3 hygienists working for him, and he could see up to 30 patients a day. As a result of the virus, in the short term, the practice of dentistry will be significantly impacted. The measures that the dentist will be required to make to disinfect his workplace and protect he and his employees will decrease patients seen from over 30 a day to maybe 8 to 10 a day, which of course will create a significant reduction in his income. One of the tenant's issues here, and this is an important consideration when dealing with any tenant, is that he personally guaranteed the lease, which has 40 months remaining. This tenant pays about $20,000 a month rent. So when you do the math, his exposure is $800,000. Another example is we represent an office tenant with approximately 25 employees in the advertising business. Tenant is able to continue a portion of that business, perhaps 40%, by employees working remotely. Tenant has applied for relief through the CARES Act, but because his workforce increased this year, all funds received will need to be applied to payroll, and he does not anticipate having any funds available for payment of rent. Note that this client's lease has the force majeure provision, but that the payment of rent cannot be excluded. In other words, that's an independent covenant. So this tenant has reached out to the landlord for rent relief. The landlord responded, this is very typical, well, what do you have in mind? He considered the idea of an abatement of rent, but instead has offered to defer rent for the months of April, May, and June, with the offer to repay the deferred rent over the balance of the lease, which in this case is approximately 38 months. So if the landlord accepts this, his rent's going to go up, when he starts paying rent after June, it will go up about $1,000 a month. He also plans to revisit the issue with the landlord in June, and depending on how quickly his business recovers, may request additional rent deferral. Now, this tenant may have some additional leverage as the lease is not guaranteed. A third example, and this is a short one, is where we represent a landlord whose tenant is in the office sharing business. You can imagine right now that tenant does not have much income flow. The tenant requested rent relief, and our client was willing to offer forbearance of rent through July on condition that the tenant apply for relief under the CARES Act. Landlord's proposal requires the tenant to file an application for relief under the CARES Act with evidence that the application has been submitted on or before April 18. To the extent the tenant receives any funds from the government, they are to be applied to gross rent to landlord. Any amounts remaining unpaid then are to be amortized over the balance of the lease. Again, that's a very typical factual scenario that we're seeing now in terms of the interplay between landlords and tenants. Landlords want to defer rent for allowing to defer rent for a short period of time, but they do want the rent repaid. Whether or not rent abatement will be accepted by landlords, we'll have to see.
So let me ask you on that real quick. So, you know, we're hearing a lot of these similar situations in landlord-tenant negotiations. When you're saying abatement, Barry, you're saying they completely forgive, they just waive the rent for those. Is that what the tenant is asking for, a waiver of rent?
Yes. Well, one of my tenants wants a waiver of rent for half rent for 6 months. Now, the half rent, and this is pretty interesting, you know, he's in a building that they pay. It's a triple net lease, so he also pays taxes and share of real estate taxes and operating expenses. So in this case, the half rent will cover landlord, in a way you might say landlord's out-of-pocket expenses for operating expenses and rent, and taxes, and plus there'll be a little bit extra, all right? From a landlord perspective, what it probably doesn't do, that if the landlord has a loan, will it be enough to cover, you know, the debt service that landlord has to pay? In other words, operating expenses, taxes, and debt service. From landlord's perspective, I don't expect them to jump up and down about this proposal. All right. So, you know, and you know, this is very fluid right now. Like, you know, if tenants aren't paying rent, you know, really, who ultimately is going to be the person, I'll say, holding the bag? All right. Who is going to bear the cost of that? All right. Is it the landlord? Well, if the landlord doesn't pay the lender, well, then it's the lender, you know, holding the bag. And then, you know, they're going to say, I'm going to foreclose. So whether or not the government's going to step in and start offering relief to lenders or, you know, I don't know. I don't have that crystal ball. But that's some of the
but you know we do find ourselves in a situation. And I want to get David Yance to chime in here, because David, you have a lot of experience in negotiating leases and representing landlords and tenants, and that's very active, obviously, in Chicago. What are you seeing? Because we're obviously kind of past that point where people may be catching the virus, people may need to be reporting that they have somebody infected. We're now at a point where, like we said, rent is due for April. Rent was due last week, and now we are in modification negotiation stages. What are you seeing? You know, Barry just gave us a good snapshot of what he's seeing from some of his clients. What kind of lease modifications are you negotiating, and have any gone to signature at this point?
Yeah, so in the last couple of weeks, I would say a significant part of the work that I'm doing is representing the landlord with its various tenants who have requested rent relief. The biggest two things I'm seeing, at least from the landlord's perspective, are one, the landlord needs certainty, and that is the landlord's going to be much more receptive to a thought out request. For example, I need to defer rent for May, June, and July, which I will repay in 6 monthly installments commencing January 1st, 2021. A landlord's going to be much more receptive to that versus a tenant that comes to them and says, the house is on fire. I need to stop paying rent until COVID-19 and its aftermath is done. I think, you know, a lot of the conversations I'm having with tenants are, here's the proposal, we'll agree to defer April, May, June rent. And the tenant says, okay, that's all well and good, but what happens when we get to July and my business still isn't recovered? And that's a fair point, but at the same time, and I don't really have a good answer for that. I think that at least the landlords I represent have been somewhat reasonable in recognizing that tenants are having trouble paying rent, and they're going to have relief one way or another. But at the same time, the landlord's not going to be in a position to say, you know, rent is just deferred for some unspecified period of time until everything gets back to normal. And the second thing is, and Barry pointed out this, but the landlord's interest in preserving the overall amount of rent that's going to be paid. And we're going to get into this a little bit later, but if I'm a landlord and I have to go to my lender because I'm seeking a loan workout, or because I'm just seeking, you know, consent to enter into all this leasing activity, it's going to be a lot better for me if I can show the lender that I'm not losing, over the life of the term, I'm not losing any income. It's a temporary setback for these 3 months. We're going to be cash poor, but then it's going to be made up. So I do see a push for landlords deferring rent versus just giving an outright abatement, saying that I'll defer 3 months worth of rent, and then starting January 2021, let's say, after presumably this is all passed and businesses have recovered, then you start paying me back in monthly installments. So those are the two biggest discussions I'm having. And I guess the third, to Barry's point, on the PPP loans, I have seen landlords, put in provisions that say, to the extent that tenant gets proceeds from a PPP loan, they'll need to apply it to rent. And my personal opinion is that the benefit that landlords are going to see from that is somewhat minimal, in that only a relatively small portion of the money that a tenant's going to get can be used towards rent. And I tend to think that tenants are going to, err on the side of using the money to pay payroll versus rent, so that the loan is forgiven under the PPP program. So that's what I'm seeing so far.
Thank you, David. And David Johnson. And so I think what's probably beneficial to tell our audience is, we are seeing, just like in any contractual negotiation or any transactional relationship, we are seeing all the different personalities as one might see in the real estate landscape. And what I mean by that is, we are seeing tough landlords, we're seeing tough lenders, we're seeing reasonable landlords, we're seeing tenants that are being very forthcoming and transparent. So we're seeing everything. We're hearing from some clients that are landlords saying, listen, unfortunately, I've got to exercise all of my rights and remedies. I've got to be a tough guy here because I don't know how this is going to play out, and I got to reserve my rights. We're seeing others being more reasonable. And I'm not sure there's a guiding light here, but it's going to be driven a lot by the business owners and their particular circumstances. One thing I asked David Wayne yesterday when we were talking about this subject matter is like, well, David, I have a lot of aggressive clients myself that are saying, well, you know what, I'm going to sit on my hands. I'm not going to make any rent payments, and then I'll go back to the landlord after I figure out if I get any relief, and then I'll have a conversation. But for now, we're all stuck in the same boat. And David Wayne, your advice was that's probably not the right approach. And what was your advice when we talked about it yesterday?
Yeah, when we talked about it yesterday, my take on it is, from a litigation standpoint, is never put yourself in a position to be in default if you can avoid it, right? I mean, you don't want to take a hardline stance and say, I'm not going to do it. I'm going to put myself into default and then try to backtrack and be reasonable with the other side. It's just not, it's not really the best way to handle this. This is as I said earlier, really unusual times. And, right now, the best thing that everybody can do is to talk with each other and try to be transparent and open and try to work through issues. Taking a hardline stance in any aspect isn't really the right course of action. And there's a lot of reasons for that. And if you want, Luis, I can get into the sort of litigation issues, the sort of practical and actual issues that we're seeing. Or if you want to hold on to that a little later in the discussion, we can get into that now later as well. But I think there's sort of a practicality aspect of this as well, that even if you want to take a hardline stance, you're going to have some significant challenges as it relates to getting into court to do that.
I agree. And one thing that we've been giving a lot of our Barry, I'll let you chime in a second. And one thing we've been giving, the advice we've been giving a lot of our clients is, and another thing is, when you do memorialize any of these kinds of dialogues that get to a modification or amendment stage, we want to paper them as amendments, as agreed upon modifications. We've been telling our clients, it's up to you, but if you really start recognizing that a default has taken place, or that is a forbearance or some kind of letter agreement documenting a default, think about what that does to your asset next time you do an underwriting to a potential purchaser or a refi lender, when they ask you, well, how many defaults did you have in the last 5 years? Hopefully you don't have any, because you've documented them all as modifications and amendments to the existing terms for a brief moment in time. Barry, I interrupted you. Go ahead. What were you going to say?
Right. Well, I couldn't agree with you more where you were saying that there's like a wide variety, a cast of characters. Some people taking a hardline approach. I would, I guess my style, what I would try to do is keep negotiating, keep the lines of communication open, even if you're a tenant, the landlord says no, or vice versa. This is, interestingly, if, we were sent home on 3/17, on March 17 or 18th, and everyone thought, okay, this is going to just be 2 weeks. At that point, let's just say things have just changed dramatically. So this is going to be a more long and drawn out process. And we don't know how long the economic disruption is going to be. So just keep negotiating, keep lines of communication open. As you just said, maybe you document something. This is what we're going to do for the 3 months. We revisit it, and then we'll see what's going to happen. And everybody in this chain of landlord, from tenant to landlord to lender, they have their issues and concerns that they are addressing on a daily basis.
And so, saying that, so David, go ahead, David. David, wait, you were going to mention litigation. What if people can't reach without modifications? Or what else were you going to say? Pardon me.
Yeah, so I was just, you read my mind. I was just going to touch on that. I think that, like, look, you have a right to file litigation. The problem is, and I can tell you from experience, I filed about a week and a half, 2 weeks ago, we filed a lawsuit. It wasn't an eviction action, because I can get into that in a second, but it's just a breach of contract claim. We can't get anybody at the sheriff's office to serve the summons. And so, because nobody's responding, they're, either they're closed or they're just not doing it right now. And so there's sort of an actual moratorium in some respects, and most of what we're seeing on the moratorium side of things is really dealing with residential evictions, residential foreclosures. But you'll see both at the local and at the state and at the federal level, there's various moratorium orders in place. Most of them take you into like mid-May. Cook County, for example, there's no residential eviction orders to be, nobody's to be evicted from properties until May 18th at the earliest. Illinois got in the governor's executive order talks about, similar language, no residential evictions. I'll paraphrase it, but basically saying during the state of emergency. Federal, under the CARES Act, there's some moratoriums in place. So there's some actual moratoriums in place with respect to certain types of cases. But then there's also a practical moratorium in place. And that's kind of the example I was just discussing where I'm trying to get the sheriff to serve somebody. Most courts outside of emergency proceedings or criminal matters, most courts now have pushed things off, all court dates, until mid-May. Again, Cook County, there's no court dates being set really until May 18th at the earliest. And so even if I want to go file an action, and even if there's not a moratorium per se as it relates to commercial real estate or a commercial loan, I'm not going to be able to get heard. I may not be able to get anybody served, and I'm certainly not going to get heard for some period of time. So talking and trying to work through things, particularly because you're not going to be able to get the relief you might want to get in court right now anyways, seems to make sense for a whole lot of reasons.
So speaking of that, and speaking of talking and having a dialogue, I think we want to spend some time, albeit briefly, on lenders, right? Just like you said, you can't really negotiate. If you have a loan on your property and you have tenants, you're going to need to get the lender consent to mostly likely all of these modifications. They're going to need to be in the loop. David Yonts, have you started having some dialogue with lenders yet, or what are you seeing? What are you looking at? I mean, I know we had a conversation in another platform where we talked about, well, listen, some of our clients were asking, what should I look in my loan agreement to talk about, have this conversation? And it was like, put your loan agreement to the side. Call your lender. You're going to have this is a different type of conversation. So David Yonts, what types of conversations, have you started having these conversations yet, or are those next week conversations?
I think for the most part, I think the discussions have initiated. I think for the most part, the activity that we've seen so far is loans that were already troubled from the, prior to the COVID-19 situation, and this has just made things worse. But, I think certainly it's going to be, in the coming weeks, we're going to see more and more. And to your point, even if you have a fully reserved, even if your loan is interest only and it's fully reserved, so your concern is not paying debt service, there's going to be other provisions in your loan documents that you're going to need to address. You touched on one already that, if you're sending default notices or if you know that your tenants are defaulting, there's probably a disclosure obligation. Your mortgage or assignment of leases and rents almost certainly says that you need the lender's consent to negotiate lease amendments with your tenants. Certainly, at least for major tenants. I think the discussions are going to start happening. The clients that I've been dealing with so far, I think, are more of the mindset that figuring out the landlord-tenant side is the most exigent thing to do. To get your tenants, get your agreements with your tenants in place and sort of work with the lender later. I think that's a business decision. And I certainly think it's prudent to start having the discussion with the lender as soon as possible. But I just don't think we're quite at the stage where we're really seeing, you know, a bunch of actually specific modifications being worked out. I know from a colleague of ours in the Chicago office that represents the lender, they're a regional bank. They expect to have guidance in place by next week for their loan officers for specific, you know, guidelines for how they can handle requests for workouts and operational consents and things like that. So, you know, I know that lenders like landlords are probably getting flooded with calls, and I just think it's kind of a ramp up process. And most immediately, we're seeing more of the landlord-tenant side than the lender-borrower side.
Barry, Katz, have you seen anything from the lender standpoint yet, or not yet, or borrowers contacting the lenders yet?
I haven't seen it. And what David Jans says really makes a lot of sense, because we're not even to the 10th of April yet. So to a certain extent, even if a landlord hasn't paid rent, that party may not even be in default yet. Okay.
Right.
So I would say next week is about when those conversations start, and they probably start in earnest if a borrower misses payments 2 months in a row. But as David Wayne said earlier, the key thing here is communication. Reach out to your lender and let them know what's going on. And I think all parties are going to wait to see what kind of government intervention there will be in this sector. Go ahead, Luis. I interrupted you.
No, I was going to ask David Wayne if he had anything to offer on this topic before I had some questions.
Yeah, no, I mean, I agree with the comments that, you know, that David Jans and Barry had said. You know, again, consistently with what I said earlier, you know, communication is the key. Like running into court, as I said, even if you as a lender, for example, have the ability to file a commercial foreclosure action, you're not getting anywhere for a while, most likely anyways. And, you know, maybe it varies from county to county, but generally speaking, I think you're going to have some trouble. And what's the end game? Even if you foreclose and take some property back, is that really the end game that you want under these circumstances? Or is it better to try to work with somebody to allow them to try to keep their property and try to stay viable and allow their tenants to stay in place? You know, so I agree with what Barry and David were discussing.
Well, and you touched upon this a minute ago, David Wayne. In Florida, we have different executive orders, and you have in Illinois, and then we have different executive orders on the county level. So, for example, you mentioned, I think you touched upon it earlier, the executive orders that are in place for Cook County and state of Illinois, do they touch upon commercial foreclosures, or is it all residential? Or are commercial foreclosures stayed for 45 days in Illinois and Chicago?
Yeah, they don't. I mean, so Cook County is residential. The Illinois executive order talks about residential evictions. And even under the CARES Act, it talks about residential property. Multifamily can be included for some of the moratoriums that are in place, but it hasn't taken it the next step to deal with commercial. At least I haven't seen that. And I don't know off the top of my head if some of the other counties in Illinois, for example, are expanding that. But there is this practical moratorium, as I talked about earlier, that just because you can't get into court anyways. So it really it really creates the same type of, the effect is the same, even though the way to get there is different.
And I think what we'll expect to see when it comes to landlord negotiations will be similar to what we were talking about before. You have different personalities, you have different types of lenders, right? You have hard-nosed lenders, you have your long-standing lenders, you have 10, 15 loans with over the past 15 years, they're going to be a relationship lender. And they're also going to hopefully work with you to the extent they have. I mean, we're all going to be creative, I think, for our clients, and we're telling our clients to be creative, and they're already probably thinking this if they're sophisticated, about asking the lenders to take any reserves that they have on hand to apply them to carrying costs. I think everybody at this point going forward is going to be like, how do we keep the property afloat? Carrying costs being real estate taxes, insurance, and then to the extent we have any extra cash flow, hopefully it'll go towards some of the debt service, if not further reserves. I think right now the immediate recommendation is to try to stop the bleeding and have those conversations. Although those conversations haven't started yet, I mean, hopefully they have started, but they haven't been memorialized in writing yet, and hopefully the lenders meet them halfway. And I wanted to shift now to the CARES Act, since we only have about 10 minutes to go, because all of this, and it's already come up earlier in the conversation, about how the CARES Act is obviously going to influence a lot of these conversations, like David Yance mentioned, and some of his lease modifications, Barry might have mentioned as well, where they want some transparency. They want, and maybe it's on both sides, right? Probably more often than not, the CARES Act is probably helping tenants get some kind of financial relief, and the landlords want to know, well, what kind of financial relief are you getting? And that should probably impact of how much should come back into my pocket to the extent any can go into my pocket. And I know obviously the CARES Act is pretty fresh. Although it's fresh, people dove in on Friday. I know the site was, a lot of sites crashed. I know some lenders hit capacity and now they're trying to open up the applications again. And I think probably the most, from what I've heard from my clients, obviously the most popular component of the CARES Act is the Paycheck Protection Program. They're calling it the Triple P. And because that's the one that has a loan structure that can in fact be forgiven. My general understanding of the Triple P is that it offers small businesses, and that's kind of a bit of a misnomer too, because small business means up to 500 employees, I believe. Small businesses have the ability to have 2.5 months of payroll, quote unquote, costs loaned to them. And if they properly use the loan proceeds towards those, quote unquote, payroll costs, they'll be forgiven. And David Wayne, I think you and I have talked about this a little bit. That, you know, it's kind of a misnomer to say payroll, and it's not just payroll, it's payroll costs. What expenses do you understand fall within that definition of payroll? And am I right, it's about 2.5 months worth of quote unquote payroll costs that the Triple P covers?
Sure, yeah, it is. It's loans up to 2.5 times average monthly payroll up to a maximum of $10 million. So there's a cap on it right now. And so in terms of what is deemed to be a payroll cost, it obviously includes salary, wages, commissions. It can include cash tips or equivalents, but it also could include payments for vacation or family or medical leave or group health care insurance payments, retirement benefits. And it actually also includes state and local taxes. It does not include federal, I suspect, because the federal government's giving you this money. They don't also want to give you the added benefit of having you use it towards having federal taxes being counted towards it. So, so there's a lot of things that it can be used towards. And the name of the act itself is a little bit of I don't want to say a misnomer. It's called the Paycheck Protection Program. But what's kind of important to know certainly for tenants and for owners, is the money can be used towards other things other than payroll. It can be used towards interest on mortgages. So for an owner, that's helpful. It can't be used for principal, but interest. It can be used for rent. It can be used for utilities. It can also be used on some other interest. There are some limitations on it, in that really what you want to do is you want to try to, if you're getting one of these loans, you want to be able to qualify for 100% forgiveness if you can, right? Because you don't have to pay a penny of it back if you qualify, and it's not even a taxable event, which loan forgiveness is typically treated as a taxable event. Under the Act, it would not be if you qualify for the forgiveness. But what you have to do is you have to use at least 75% of the proceeds towards payroll, and then you can use the remaining portion towards the rent, the utilities, and the other items that I'd mentioned, the interest on the mortgage. And if you do that and you follow some other steps, then you can hopefully qualify for 100% forgiveness. Even if you don't, though, and even if you use 40% towards rent and mortgage interest, et cetera, the good news is this is about the most favorable loan terms you're going to find. You know, it's a 6-month. Right now, it's a 6-month payment deferral. It's a 2-year term, and currently the interest is at 1% on it. The maximum under the Act is 4%. But they have it at 1% interest right now. So even if you have some portion of it that's not forgiven for one reason or another, it's still really favorable terms to get cheap money.
Right, and I think what we've seen a lot. I mean, we've been receiving some calls from our clients for general guidance, but this does really, for some of our very proactive clients, it's really kind of a financial documentation exercise. The application is pretty vanilla. And it's really clients working with their accountants or clients that have their own good books and records in-house are putting together the documentation themselves to submit the application. And I haven't heard of anybody getting any funds yet. Have you, Barry Katz or David Yance? I just know applications have gone in.
No, I don't know of anybody, but yeah.
And David Yance, what about you?
No, I haven't heard of anyone actually seeing proceeds to date. No.
And Barry Katz, what types of clients of yours have submitted applications? I've had like a small general contractor. I've had property managers. What are you seeing? Who's submitting applications from your client base?
Well, in these examples that I gave, the tenants, the dentist submitted, the advertising agency submitted. I have a client that rents blocks of apartments in buildings and then puts short-term, corporate kind of transfers in that they've applied. I think anybody who's impacted is applying. So the real question is how quickly the money becomes available. And, we get every day there's announcements from the Treasury Secretary and those people that say, yeah, it's going to become quick, will come quickly. It's sort of like I'm taking a, well, we'll believe it when we see it approach, when it hits people's paychecks.
Mm-hmm. Yeah, and if I could add,
go ahead.
Yeah, I wanted to add real quickly. I describe this as the Mad Dash for Cash Act because it's, everything we're hearing is, if you haven't applied for it, get your application in sooner rather than later. I mean, who knows if it's even too late, because it's really, in large part, it's a first come first serve, in terms of getting this money. Now, what we're hearing on the street is we kind of expect that and again, speculation, but we kind of expect that if the program, is run smoothly and, that more money may be made available under it. But as of right now, there's nothing official on that. But, kind of hearing through the, kind of reading the tea leaves and through the grapevine or whatever, that there may be more money down the road. Again, a little bit of speculation, or certainly a lot of speculation on our part. So point being is if you haven't done it yet, get your application in, follow up with your lenders about it, because the money, everybody's putting their applications in as quickly as possible to try to get their piece of it.
Right, and this then goes to when we start having those dialogues with lenders or with landlords, the more proactive and aggressive you've been trying to get some relief, that shows that's another good faith step, obviously, for the clients to be doing that. Before we wrap up, Barry Katz, is there something I didn't cover that you maybe wanted to raise during the discussion?
Basically, I think you've covered, most of it. I would just say my practical advice is that over the years, I've come to know that most, legal questions do not have a black or white answer, but rather live in the gray area. And so the answers as to whether or not a tenant's entitled to relief or whether the landlord can evict and receive damages can't be answered right now, even though many of our clients are demanding that there be a black and white answer. Just because of the unique and uncertain situation caused by the virus and the not knowing how long the economic disruption will last. That's why we touched it earlier, keep negotiating, keep the lines of communication open.
Fantastic. David Jans, do you have anything to add to that? That was pretty well said, but maybe you have some that maybe from the borrower standpoint or the tenant or landlord standpoint?
No, I echo Barry's thoughts. The only thing I would mention is that I neglected to say when we were talking about what we're seeing as far as loan workouts, that if for those in the multifamily sector, if you have a federal back loan from, from Fannie or Freddie, that they have an automatic, as long as you ask for it, up to 90 days of automatic forbearance. And what I'm hearing is that if you have a deal in the pipeline that hasn't closed yet, that Freddie and Fannie are encouraging that to go ahead and close, keep deals moving, keep deals in the pipeline, and then immediately ask for their forbearance once you've closed.
Oh, that's great. I didn't know that. David Wayne, did you want to add anything before we call it a day?
I think I pretty much covered my talking points. The CARES Act could be a subject in and of itself, obviously, and there's a lot to it. And, I would say if anybody has any questions on that or anything else that we've talked about, do not hesitate to follow up with us after the fact with emails. We're happy to get back to you.
Absolutely, yes. And if anybody needs some South Florida advice, they can reach out to me. I would like to thank everybody for participating in today's teleconference. On behalf of everybody on the call, I want to thank David Wayne, Barry Katz, and David Jans for the time and effort they put into today's discussion. Obviously, they've had a lot to think about and brought a lot of real-life situations, examples to discuss. If you have any follow-up questions, like David Wayne mentioned, email any of us. Our email addresses should be on the profiles that we're distributing today's materials. I hope everybody's doing well. A month from now, we're back in our offices. If not, we'll be having some more teleconferences of this sort. Enjoy your weekend, everyone, and thank you for your time today. Thank you, David, again, the two Davids, and thank you, Barry.
Take care. Thank you, Luis.
Luis, thank you. Thank you for your time.
You guys got it. like I